Hello everyone, today we are going to discuss about coincidence of actus reus and mens rea. Introduction. So far we have learned that criminal liability requires actus reus and mens rea. Actus reus is the external element in the crime package. Mens rea is the internal element that which the prosecution has to show was going on in the defendant's mind. We need to understand something further about the elements, namely that in relation to any given crime, actus reus and mens rea should in principle coincidence. There are two facets to this premise. The first is the actus reus and mens rea should coincide in point of time, that is, liability should depend upon proof that the defendant had the relevant mental attitude as at the moment of doing the acts which form the actus reus of criminal offence. This is known as temporal coincidence. The second facet is that offense definition should match any relevant conduct, consequence or circumstance with an exactly matching mental state on the part of the defendant. This is known as the correspondence principle. Without such correspondence, it is thought that defendant will be punished for the wrong harm. Temporal coincidence. Temporal coincidence is an easy concept to grasp, a lazy easy concept to apply. Here are some examples falling on either side of the liability fence. Illustration 6.1. D takes V's wallet intending to steal from it. A few seconds later he changed his mind and puts the wallet back. Is he guilty of theft? The common sense answer is number D. Momentarily had the mens rea for the theft, but since he decided to put the wallet back, there was no actus reus. This is not the legal answer. To discover this, we need to apply the lawyer's method. This requires us to consider the definitions of theft. Here is the simplified version. A person is guilty of theft if the take properly belonging to another intending not to return it. This definition tells us that the offense is made out since at the time D took the property, it was his intention not to return it. Actus reus and mens rea thus coincided in point of time. We have already come across a few cases where the principles was at issue. One is Ahmed 1986, crime LR 7309, where the landlord was charged with harassing his tenant with intent to make him give up occupation. The landlord was not guilty of this crime because he had formed the intention only after he had completed the acts removing windows relied upon as acts harassment. See Wilson chapter 4.5 D.2 omissions, the common law approach. Avoiding the coincidence requirement. If act and mind do not coincide in time, this is not always fatal to a successful prosecution. This is because it may be possible to ignore the initial act and graft liability onto subsequent omission. This is what happened in Miller 1983. The act which caused the fire in this case was unaccompanied by mens rea. Since D was asleep at the time, mens rea was formed only after the act was complete, when D woke up and realized his bed was on fire. This will normally mean that D would escape liability for criminal damage. The House of Lords ruled, however, the actus reus could be based upon D's omission to put out the fire, which omission was accompanied by mens rea reluctance. Actus reus and mens rea coincided therefore at the moment of D's deciding not to put the fire out, because here the actus reus was D's omission. The crime was constituted by his reckless omission in breach of duty, actus reus. Another way in which the coincidence requirement has been avoided is by reference to the continuing Egg Doctrine in Fagan vs. MPC 1969. There appeared to be a classic example of case where the mens rea and actus reus did not coincide. Since mens rea was formed only after the harm-causing act had been performed, D had innocently parked his cars on a police officer's foot, which he realized only after he had turned the engine off. At the moment he decided not to remove the car. D was convicted at first instance of assaulting police officer in the execution of his duty. He urged that there had been no assault since the act of assault took place without mens rea, and when he later formed the mens rea, there was no accompanying act. It was central to his argument that assault required an act and could not be committed by omission. The Queen's Bench division agreed that assault required an act and could not be committed by omission. Nevertheless, it affirmed the conviction. The supposed corpse cases. The principles in Miller and Fagon constitute two qualifications to the rule that actus reus and mens rea should not coincide in point of time, but they are not exceptions. They are ways of avoiding its application. The supposed scope cases, however, are an exception to the rule. These are cases where the defendant has attacked the victim and wrongly concluding the victim is dead, disposed of the body whose disposal is the actual cause of death. Correspondence principle. Simply put, the correspondence principle requires a corresponding mental element for each aspect of the actus reus, that is, conduct, circumstance, and consequence. The principle derives from the broader ethical principle that conviction and punishment be deserved. If a person can be punished for doing acts without a mental element corresponding to acts, then the punishment is undeserved and unfair. Transferred malice a qualification to the correspondence. No breach of the correspondence principle occurs if the defendant commits the formal actus reus of an offence with the relevant mens rea for that offence, but the subject matter of that actus reus was other than that intended or foreseen by the defendant. Illustration 6.3. Intending to shoot B dead, Mrs. B and kills C, an innocent bystander. D is still guilty of murder. He has the mens rea for murder and he has committed the actus reus of murder. He has also committed the offence of attempted murder in relation to B. The criminal law permits the mens rea in relation to B joined to the actus reus committed against C. This qualification is known as the doctrine of transferred malice. The effect of transferred malice is that the intended victim and the actual victim are treated as if they were on, so that what was intended to happen for the first person but it did not happen is added to what actually did happen to the second person but was not intended to happen, with the result that what was intended and what happened are married to make a notionally intended and actually consummated crime. The cases are treated as if the actual victim had been the intended victim from the start. The effect of transfer malice is the intended victim and the actual victim are treated as if they were on, so that one is intended to happen the first person but did not happen is added to what actually did happen the second person but was not intended to happen, with the result that what was intended and what happened are married to make a notionally intended and actually consummated crime. The cases are treated as if the actual victim had been intended victim for the start. The principle applies to all kinds of violence, not merely murder. So in Latimer, which means X and hit V standing behind him, D was found guilty as a result of against V, although he neither intended to hit V or nor even knew V was there. In each case, the malice intention D iterated with respect to intended victim transfers to actus reus of the crime committed against the real victim. That's it for today. Thank you for watching.